everybody, and thanks for joining us today. We're just going to give it a few more minutes to let the rest of the attendees dial in, and then we'll get things started. Okay, I think we've got quite a lot of people in now, so we can get started. Hello, everyone, and welcome to this masterclass on private equity with Ropes and Gray. This is our first masterclass of the new year, and we've got a great panel today and a lot to get through. So we hope that you enjoy this masterclass and learn a lot about the practice area and the firm as well. So we always start our masterclasses with our learning outcomes. So by the end of this masterclass, you should know the fundamentals of private equity, know what the work of a private equity associate involves, and learn more about Ropes and Gray and the life cycle of a private equity deal at the firm. Before I hand over to Lucy and Alex, I'm just going to go quickly over some house rules. So first and foremost, please use the online question tool to post any questions that you have, and I'll be posing them to our speakers at the end. It's also worth noting that we have a lot to get through today, and we really want this session to be focused on private equity. So please keep your questions about private equity, about the presentation, or the work that Lucy and Alex do. If you have any questions about the firm's graduate recruitment process, such as vacation schemes and training contracts, we'll be sending out some links in the follow-up email, so you can go off and take a look at that then. Please note that this masterclass will be recorded. The recording of the session will be sent out to all registrants after the session, and it will be also available on our YouTube channel very shortly as well. We have some fantastic events coming up over this term, so please check out the lawcareers.net events page. We're hosting a series of boot camps with the University of Law. There's a specific boot camp for second and third year law students, which is next Tuesday. In this boot camp, you'll learn all about how to research firms and make applications, and you also have the opportunity to network with firms as well. The other two boot camps are for first year students, and there's one for non-law students as well. So make sure you register for the one that matches your stage. We also have a masterclass for non-law students next Wednesday, as well as three other upcoming masterclasses with BBP University on topics such as how to succeed at SQE, how to fund your legal studies, and top tips for developing your commercial awareness. I do know that was a lot of information just now. So again, make sure you check out the LCN events page for more details. And just before we get started, I'm going to ask all our attendees to answer the question that will pop up on your screen now. Thank you to everyone that voted. Let me just share these results. So it seems like we've got quite a mix of students. Got a few first year law students. Mostly we have postgraduate students and people in work. And then we also have like an equal amount of second and third year students and non-law students as well. And then if you could please also answer the next poll, which is kind of to get an idea of how much you know about private equity already. So if you could please vote for that one as well. Just going to end the poll there and share the results. So quite a lot of you have said that you know a little about the practice area, which is great. And we look forward to your questions and also hope you can learn even more. And quite a lot of you have said absolutely nothing, which is, again, totally fine because this is what this session is all about. So thank you. I think this gives us a great idea of who joined us and how much you already know. That's it for me for now. I'll hand over to Alex and Lucy.
Thanks, Timothy. Welcome, everyone. My name is Lucy Taylor. I'm an associate, sixth year associate in the Ropes and Gray London private equity team. I've been at Ropes for 3.5 years now, and prior to that, I trained in a different US law firm. So I've been in US law firms my whole career, but I've been at Ropes for about 3.5 years. So that's me, and I'll let Alex intro as well before we get to talking about private equity.
Hi everyone. Hi, I'm Alex. I'm an NQ here. I trained in our London office. So sat in, my first seat was finance, then did PE, and then I took secondment to the Tokyo office, and my fourth seat was in antitrust. And yeah, it's my coming up to fifth month as an NQ. So it's been, you know, I've had good experience transitioning from being a trainee to an NQ.
Great. I'm not sure who has the control of the slides. If you want to just roll forward one. Great, thank you. So introductions we've already covered. What we're going to look at today is a look at what the Ropes and Grey practice does, a look at what private equity means, and then we're going to dig a little bit more into the things that we think about when we're coming at a deal, the key documents that we think about, due diligence, as that's a really important stage of a deal, but particularly when you are a trainee and a junior, that's one of the areas that you really get your teeth into. So we're going to dig a little bit more into that as well. And then just to complete the life cycle of a deal, we're going to take a quick look at completion and exchange. And then because Alex trained here and we've got that knowledge, we're going to have a look at the trainee role as well. So that's there's our lovely photos. We already did our intro, so we'll skate past those and take a look at Ropes and Grey. So as you can see on the slide here, Ropes is a very prominent private equity firm. It's what I would call dedicated to private equity. So where some firms would describe themselves as full service, or that they may have a particular sectoral interest. You hear firms that are very focused on energy, media, or something. Ropes and Grey really is at its core focused on private equity. And so whilst we have a really broad range of departments and seats within our training contract here in the UK, the firm as a whole is very focused on private equity, and it's at the core of what we do. And in part that's why it's one of the firms at the forefront of the market. It's part of a much bigger practice in the US, where it's also pretty well ranked on all of the legal lists. So yeah, I'd welcome you to have a look at the profile. If you want to dig further into that. That was just to say that as someone who's been here 3.5 years, that is the main takeaway for me, is that that is what is at the heart of the firm, private equity, and it's for Alex and I, we have the pleasure of working in that team. We can tick. Perfect. Oh, okay. So we've got a look here at some of our clients. And we didn't have a poll to see, how many of these are familiar to you. But if for those of you who said that you know a little bit about private equity, I'm sure some of these names are familiar. There's a mixture here of what we would call sponsors, private equity funds, and then there's some corporate clients nestled in there as well. Alex, did you want to take this? I'm happy to do it. Did you want to?
If you can carry on.
Sure. Will do. So when I guess that taking a step back, what do we mean when we say private equity? In broad terms, what that means is private money, and that's opposed to if you got money from a bank, that would be debt. And so if you're trying to raise money within a business in order to grow, in order to expand, perhaps in order to make purchases or capital expenditures, then you need to raise money to do that. You could look at taking out debt, or if you are of a certain size, you could look at listing. So when we talk about public companies, your Unilevers, those are listed companies, and they raise money by their shares being available to the wider public to purchase shares, and that's a way that they can raise money. Private equity basically covers everything that's not in those two categories, and so that's investments in your unlisted or sometimes unquoted companies. That's through shares, but it's shares not just to the broader public, it's to our sort of limited pool of people who are bringing that private equity, rather than just sort of I have a share in Unilever, you would be a shareholder, but that's on the public market rather than coming from a private equity space. You could potentially also have shareholder debt if one of our private equity clients was sort of loaning money into the business, and you can have a smaller kind of subset of debt within our equity space. But it can range from everything from a brand new startup. So that's when we think about things like venture capital, and we're talking about startup capital. That could be private equity, right through to but buyouts that sit alongside debt in huge companies that, or potentially companies that are listed currently and we're taking them private. So it really is the scale from the smallest of companies to the biggest of companies. As long as we're talking about private money and the company being private, that could fall within private equity. And so it's a very, very broad umbrella term, and doesn't really tell you exactly what we do, and we'll dig into what we do within that space a little bit later. In terms of who invests in private equity, it can be your big pension funds. They're big investors. They often themselves invest within private equity funds. It could also be a family office, so that is just your high net worth individual who has a family trust structure in order to make investments. So it's everything from an individual with private money to a collective of people with private money. Sovereign, and there's a couple of other examples listed on the slide here. Sovereign wealth funds, that's a similar concept, but where the whole fund is tied to a country, such as Singapore or Norway. They have very, very large sovereign wealth funds which make investments. For us at Ropes, we would typically be dealing with B here on the slide, which is private equity funds. And then sometimes the deals, however, you interact with all of the other areas of the private equity space who might be involved. There might be minority shareholders on a bigger deal. So it's worth bearing them all in mind. I think we can. Great. Something that's important to try and get a clear understanding of as you're learning more about private equity is what we mean when we say the equity work stream and the acquisition work stream. Because they do get used interchangeably, as does, and perhaps I should have said this on the previous slide, M&A as a term, which you may be familiar with. So that's short for mergers and acquisitions. In the UK, we don't really do mergers because that's not a UK type of law. What we deal with is acquisitions, i.e. one company acquiring another company. And that can happen with or without the private equity piece, but often we're dealing with both. And so we'll have a company that's buying another company, but the ultimate owners are private equity funds. So there's a private equity element, but it's also an acquisition. And then within the company that you're buying, sometimes the owners of that company, sometimes they don't own shares actually, but the management of that company have to be involved with the sale of that business in order for the sale to be a success, because you'll see, we'll touch it time and time again as we move through other areas, documentation. The management are the heart of the operation of a business, and you need them to be involved with preparation of the documentation, but you also, that's part of the value of the business, and you need them involved in the go forward business. And that often means that you're putting in place incentive arrangements related to the management team. And so they'll essentially own a little bit of the company going forward. You've given, you're coming in as the private equity buyer, but the management team are also going to own a little bit, so that you're all aligned and invested in growing the business after the acquisition has taken place. And so that's why we have these two work streams. We have the acquisition, which is the actual mechanical acquiring the company, and the equity, which is you coming in as a shareholder, potentially management coming in as shareholders, potentially there was more than one buyer coming in if you were doing it sort of as a joint acquisition with another PE fund or a minority shareholder. And you need that documentation on the equity side to govern that relationship between you as investors and the company. So taking a look at the notes on the slide here, what we mean by acquisition, as I say, that tends to mean one company buying another company or investing in another company. But acquisition implies that you've taken a majority stake. So perhaps not 100, but you've acquired it. You've probably acquired more than 50%. We're definitely going to take another look at the key documentation here, so I'll try and be quick. But the key documents in relation to an acquisition are your sale and purchase agreement or share purchase agreement. That's your main document governing the acquisition of the actual shares in the company. A warranty deed. We will definitely take a look at this later. Sometimes the warranties are in the SPA, sometimes they're in a separate warranty deed. If it's separate, then that's definitely a key document. The disclosure letter and the tax deed. The disclosure letter, I know we've got a few slides on later, that goes hand in hand with your diligence process and it's one of your key documents. Tax deed, sort of unsurprisingly, it relates to potential tax liabilities that you have in the business, and that the reason that you have this as a separate document from your SPA and your warranties is that it is enforceable as a debt. So where if you had given a warranty about your taxes and that wasn't true, that would be a contractual breach. And you can then, using the usual contract routes, make claims for that breach of contract. If you have a tax deed saying that you are standing behind that you will reimburse for any tax liabilities that accrued up until the designated point, that becomes a debt claim, and that's easier. That is easier to enforce. So that's a very key document as well. On the acquisition side, on the equity side, what we mean by equity is, and I'll just keep saying it, but what we mean by equity is the ownership of the company. So if you are a shareholder, if you are investing some money, you're taking some shares, you are interested in the equity of the company. The types of equity that can include a number of things. I know the group is sort of at a stage of not knowing huge amounts. So these terms may be unfamiliar: institutional, rollover, preference shares, sweet equity. That's sort of our jargon. But to break them down, institutional, that is you paid for it, you got some equity. Sweet, that is the type of equity I was describing earlier, where if you want to incentivize your management team after the transaction, you might give them some sort of equity that has the potential for growth after, rather than that it's just a product of them investing and them getting shares. It's more tied to the performance of the business and a chance for them to stay incentivized. The key documentation on our equity work stream is so quite often when we sign the deal, what we sign in terms of the management arrangements is just a term sheet. That's 2 or 3 pages of the headline terms of what management's equity arrangements are going to be, that incentive piece for management. We might just sign a few page sort of term sheet with the core terms of that, rather than signing all of the actual documentation for management when we sign our agreement to purchase the shares on the acquisition side. The investment agreement, this should really be this is your most important document on the equity side. This is your agreement between investors and the company as to how governance, how the transfer of shares, how voting in relation to your shares, all of the core arrangements that relate to investors sit within your investment agreement, and that is by far your most important document on the equity side. The Articles of Association, as I'm sure many of you know, that is the constitution of the company, as it's sometimes called in other jurisdictions. That is the core governance document for a company itself. So it does determine what directors can do, because they need to be mindful of the governance rules of the company. But it's not a contract with the shareholders. That's why I said, really, I think the investment agreement is the core document, because the articles govern the company's behaviour, and there are some. And the other thing to note about the articles, of course, is that they are publicly filed on Companies House, so you can look up the articles and the sort of mechanics of a company. Usually, they're detailed in the articles and they're public. And then loan note instruments, if you have loan notes, that's really the core documents. As I say, we will definitely dig into a couple of these key ones further down, but that's the headline. So I think, Alex, do you want?
Yeah.
Okay.
So yeah, I'll just talk you through some of the preliminary considerations. So, before we start drafting documents and engaging with the counterparty and the opposing counsel, we all want to understand what really is behind the deal. So starting from the top, commercial drivers include the objectives, what is the deal team thinking about, what is the motivation behind the deal. And even as the legal counsel, this is really important to know in terms of drafting documents, and also sort of like the speed at which maybe we might have to complete the deal. And relative bargaining position, again, I think when we're thinking about this, we might be important to distinguish between what type of deal it is. Like, is it set up like an auction, or is it bilateral where it's really between one buyer and seller? In an auction, the seller is much more likely to have a stronger bargaining position. And the third one is understanding the target. Again, understanding what the target business does, and in the very beginning, before we start proper due diligence process, we often get a information memorandum. So it's basically PowerPoint or a different document that the target's bankers or deal team might put together, essentially just setting out everything important that we are allowed to know at that point about the target. And this is something that is important for both PE teams and other teams within our firm to really look into in terms of understanding the business, and maybe thinking about what additional questions we should be thinking about when the due diligence process kicks off. Financing, this really goes back to what Lucy mentioned earlier, but how this deal will be structured, the level of debt and equity is important to know as well, and also whether it is likely that the buyer will be able to arrange financing on time. And yeah, the fifth point is about the timing of when the deal is being signed and when the deal is being completed. Sometimes, and one of the deals I did as a trainee, it was there's basically not a lag between signing and completion. Maybe it was like 1 month, but sometimes there could be a longer period depending on maybe getting consent or regulatory clearance and so forth. So understanding that is also important as well. And also just it relates to the type of the deal as well. Like if you are buying a public company, if it's a take private, there'll definitely be a lag there. So in terms of drafting documents and the protections you want to think about that timing as well. And I guess the last point just it relates to what I just said about sort of what factors may cause timing delays. And this is definitely something to discuss with your client as well, because sometimes you might have certain antitrust filings, but this is ultimately the client's call to make as well. They might have sort of timing concerns and want to close immediately, or they may be happy to wait until clearance is given. And the second point is, the auction process. I briefly mentioned this, but often a lot of the deals I've seen are structured in a auction where you have multiple, you send out bids and you have multiple interested buyers looking to acquire a target. And in the initial process, the level of information that is given out is limited. And I'll touch on the data room, but potential bidders might get access to certain information, and then once the deal carries on, once the seller chooses who they are willing to work with, this is when the nature of the deal might change a little bit, because you will have to think about putting together certain teams, certain arrangements for to buy this target, and you have to think about again the relative bargaining power when you're marking up documents as well. I've noticed that in auctions, typically, sellers have more of a leverage, so sometimes the documents aren't as heavily negotiated. I mean, Lucy can jump in as well, but that's what I've noticed.
Yeah, I would agree with that. It definitely can vary, and this comes back to, it always comes back to the sort of commercial drivers. If you are a seller who is absolutely desperate to get rid of an asset, and maybe the asset's not doing so well, or you've had it on your book such a long time that you're really keen to get rid of it, that could lower your relative bargaining, and then you might not get like 7 bids and they're just constantly, you'll all understand how a bid works if you think about housing, even where that drives up the market. You might have that scenario, or what we do often, I've definitely seen it both ways. If the seller's really desperate to get rid of an asset, then the buyers have a bit more leverage in the scenario, or if you've been mandated for some reason, if you have received competition sort of instruction from one of the regulators to break up the group, then the buyers know that you have to sell the asset. That changes the relative bargaining position a little bit. What we deal with in sort of the pure, what you think of as just like pure mid-market PE, you may well have the scenario that Alex is describing, where it's an ultra competitive bid, and then you have to be very, very thoughtful about your markup as a buyer, because you know that you're going up against other people who all want the asset, and you might not even move forward to the next phase unless you remain competitive. So it can definitely go either way, and it really comes down to understanding what this sort of ABC of this deal. It completely drives what that auction process will look like. Completely. Thanks, Anna.
Thank you, Lucy. And I'm conscious of time, so I won't explain in too much detail, but confidentiality agreement, NDA, is one of those key initial documents that you enter into. So is the engagement letter, which is we haven't included, but essentially NDA is a key document because it is a protection for the seller when they're disclosing information. I mean, it could also protect this buyer as well if they are providing information as well. But, as a buyer, when you want to ensure that it, as a PE firm, especially fund, if you have multiple funds, you want to ensure that it only applies to a limited subset of your company. Otherwise, all the other funds will be caught under this NDA agreement. And moving on to exclusivity, again, the exclusivity agreement sort of sets out the exclusivity period, and this is a certain period when the seller and buyer the buyer has an exclusive arrangement with the seller to purchase the target. So often, as soon as the exclusivity agreement is signed, if it is a competitive deal, you might see a buyer trying to push to sign and close as soon as they can. And then term sheet, Lucy explained earlier, so I won't get into it, but essentially it just reflects the key terms.
Yeah, so the term sheet I think I referred to earlier is related just to management equity, sort of incentive arrangements on the equity side that you might sign. I think the one here is sort of saying that you might, in the very early stages, probably less in an auction scenario, if you're sort of just two parties, your first document might be to agree the core terms of the overall transaction. You sort of agree that before you both incur the costs of having, lawyers do all of the diligence, all of the full form documents. You might just sort of be like, these are the core terms we want to agree. So it's the same concept, but this one's sort of at the outset of your overall acquisition. And then on signing of your SPA, you might put a further one in for your equity terms.
Yeah, I would say contains terms such as, price, funding, might set out the transaction timetable. But I would say it's like a roadmap for the acquisition agreement itself. Although, again, as Lucy said, sometimes people might go straight into negotiating the acquisition agreement. And moving on to due diligence. So you might have all heard about due diligence and learnt about the concept of buyer beware at university. But essentially, this is a very key work stream that often we get involved as a trainee or a junior. It is looking into the target's business, understanding the business, and flush out any potential issues at a very early stage. So as to help us negotiate terms and pricing, and it also helps us to understand, again, whether there might be certain issues to completing the deal or that may delay the completion of the deal. And different advisors actually prepare different types of due diligence. So we will, we might prepare we do prepare legal due diligence reports, but the other advisors might prepare an ESG report or a commercial report or a financing and tax DD report. So there are many different types that addresses different issues. And the nature and the scope is something to discuss with the deal team in advance. So it may cover, typically it covers corporate financing, employment, pensions, litigation, and maybe competition. And there's a different there's different scope, and even within that matter, you have to agree what to due diligence and what not to. And there are certain matters like pension and employment that we don't do. So in that case, we work with either our internal team here, such as our finance team, or work with a different law firm and then prepare a due diligence report together. And we often hold the pen on that. So as a trainee, you can really get involved with liaising with different teams. And the data room that I mentioned earlier is sort of the platform where the sellers usually upload all their documents. And this is something you get really familiar as a trainee, because and junior, because you're really looking through each and everything in there, and this is the way you understand the target and any potential issues. And moving on to the due diligence request list, this is based off of what is being uploaded to the data room. So this request list is essentially a list of all questions that this buyer, so we may ask the target management team, and it could be confirmations, or if there isn't enough information on the data room, or if we have a query about a certain document that's been uploaded, we might include this in the as an additional request, or we might put together a separate questionnaire. So due diligence questionnaire, where we have their management team respond to our question. And this is a really important sort of initial step in contact with the management team on the other side. But again, we have to be wary of not flooding them with too many questions. So this is also a good way for a trainee to sort of recognize what are the key issues here, what do we really need to ask, what could wait, and we also have to be in touch with the other specialist teams to get their input as well. And I can get into it later on in terms of how a trainee can get involved, but this is very key in a due diligence process. And finally, this altogether feeds into the due diligence report that we prepare. There are different types of due diligence report, even within the legal report. So it could be a vendor due diligence report. So that is a report that the seller prepares, or the seller's counsel prepares. And there's also buyer due diligence report. So buyer counsel prepares this, and it could be very thorough and comprehensive, covering all matters and all issues, or it could just be limited to a red flag report. So those reports really focus on material issues. And yeah, due diligence report could be quite long, 100, 200 pages, because you're really compiling information from different legal angles. And moving into documentation, I'll let Lucy talk us through the SPA.
Thanks. So as I said earlier, our main document on our acquisition workstream is the SPA, which is either the sale and purchase agreement or the share purchase agreement. It's SPA either way. It serves to make this document is often 300 pages. It's a very detailed document in a lot of cases, but it ultimately serves two main functions. That is to agree the transfer of ownership. Just a slight note, because this does say transfers the ownership. Under English law, the SPA is not the document that transfers the ownership, because we have a sort of specific form called a stock transfer form. That's just a one-page document. That is your legal instrument of transfer. So I do just want to clarify that. But what the SPA does fundamentally is agree the transfer of ownership. In the main, whichever entity has been selected as the target, and we haven't covered too much detail about what structures of acquisitions look like, but that target entity might be your main operation company that we're thinking about, or it might be a holding company that sits a little bit higher up than that in a structure. The entity that you've agreed you will be buying the shares in, the agreement to buy those shares will be set out in the SPA. And the other main function that it does, and the larger function of the two, is to allocate risk between the parties. And what we mean by that is it will say everything from the scenarios in which you have found things during the diligence. So, for example, you have found litigation, and you want to make sure that the risk of that litigation is built in to the acquisition of the shares in this company through an indemnity that will be set out in the SPA. So it's sort of everything from the big scale, this could be something that really changes the value of our target, to the risk of what happens with the actual purchase money. You're obviously paying for the shares. That money has to transfer through the banking system, and the point at which the sale has happened will be something that's a matter of drafting that's set out in the SPA. And if that drafting says that the completion of our deal happens, when we've hit send on the money, then that's allocating risk. Because if you're the party receiving the money, the deal has completed, but you may not actually have received the money because it might still be in the banking system. So everything from, issues that have come up through diligence, through like the mechanics of the transaction, are a matter of working out, who's, how do we balance the interests of these two parties, and if there's any risk, where does that lie? And that's what is set out in our SPA. In terms of who prepares it, the first draft is usually prepared by the sell-side team. That's often because we're putting an auction in place, as Alex described earlier, where we put forward one SPA as an auction draft, and then all of the bidders will review and make changes and mark up that SPA. But even if you were sort of doing it as a one side, I would think typically you've still been the party to prepare it, and that you let the buyer's team mark it up. Things that you will be considering. So parties, this is what I was alluding to earlier about which entity you're actually selling. Which entity is the seller will be driven by that, because it will need to be the entity that owns those shares that is the party. But it's also important, whenever you enter any contract, as I'm sure you've looked in your contract modules at this point, it's important to know that the party that you're contracting with is a real substantive party. You don't just want to be entering into a contract which has huge risk allocation, and money is passing and there are lots of obligations, and you really want to know that's also a substantive entity. And if factually, because of the entity that you want to buy, the seller entity isn't that, then you can look at other arrangements. But you've just got to bear that in mind. And so, first things first, think about the parties. Think about the shares that are being transferred. This is a case of understanding what we would call the cap table, the capital structure of the existing shares. Who owns shares already? Is it just a simple, we're buying something that's in a holding structure and it's 100% owned by this other group company? That's our easy end of the shares being transferred. But you could be looking at a much more complicated structure where some management own shares, some minority shareholders own shares. Potentially the shareholders are not all in the same jurisdictions. And it's just a case of, thinking about from the outset what shares are being transferred here. What shares do we need to make sure that our client ends up with if we're on the buy side? Price. Obviously, that is one of the fundamental sort of decisions in terms of whether or not you're actually going to move forward with a deal, is making sure that you have landed on a price. We aren't typically the ones who are determining the price. You sort of leave that to the commercial teams and the bankers. But where it comes in to our documents is how that purchase is being structured. So, for example, the examples given here, earnouts, deferred consideration, these are mechanisms for how you pay the consideration, whether you do that with a part held back, with a part, with additional payment that might be due later if you've met certain conditions. Other alternatives are, that money can go into a sort of independent account. Then any later risk can be dealt with that way. But this is essentially, again, coming back to our risk allocation. If there are problems down the line or things that might have a monetary value attached to them that have been identified risks, we'll look at allocating that through the way that they pay their purchase money. And as I say, it might be that it's held until a certain period and then they get the rest of it, or it might be that they do get money, but they get more money if certain things don't materialize or if certain conditions are met. So all of that price structuring is something that we would look at pretty closely in the SPA. Remedies, limitations of liability. Again, these relate to what happens if something hasn't gone right, and you're looking at have we got specific identified risks that we have got indemnities for? Are we saying that remedies can include everything from injunctions to requiring performance. It's going to depend a little bit on what the risks you've identified are, and whether whether that's something within this industry of the target business sort of requires you to do a specific kind of remedy, and making sure that you've provided the rights for you to do that in the document. And limitations on liability are a sort of protective measure to say that the purchase price was X. The maximum liability if something is wrong is going to be a portion of that, potentially not the whole amount of that. So these are ways of you, again, limiting your risk, because everybody's going into a transaction wants to come, if you're a seller, you want to come out of it with as clean a break as possible. You want, I don't want that asset anymore, and I don't want anything on my books that says I might still be needing to pay money to this buyer. So ideally, you want a time limit and a monetary limit that you can, put in black and white. This, yes, I've sold this company, we've sold this asset, we've done this transaction. It's pretty clean. These are the amounts of risk that we've been left with, and we can quantify that. So that's important as well. Conditions precedent. So this is actually more about your mechanics of the deal. Like, what do you need to be completed before you can actually say the company has been sold? And so this may be that you've got debt in place and that you need lender consent. It might be that the deal triggers some antitrust filings and that you need regulatory approval. If those things are the case, and this comes back to what Alex was talking about thinking about timing and what things you're going to need, those things need to be documented in the SPA. So you'll say, as a condition to closing, you have received that regulatory consent. And then ultimately, once all the conditions have been met, we will have 10 days until we close. And that's something that we will set out in our, and it is a point of negotiation, because it might be the case that you need something, but that doesn't necessarily mean it's a condition to closing, because a condition to closing means if you can't get it, if it doesn't come through, then it's potentially there are walkaway rights or there are fees. You can negotiate all these things around conditions. Conduct of the business. I'm mindful of time. I should rattle through these a little bit quicker. The conduct of business pre-closing. So this is, you have signed a document, you have agreed that you're selling the company, but there is a period where we're dealing with our conditions precedent, where you have not actually sold the company. This is our gap period, and the buyer will want the seller to commit that they are going to run the business the way it's been run, that they're not going to suddenly change what the business does, or that they're going to drive it into the ground intentionally during this gap period. So there's some sort of protective measures to be negotiated. The seller doesn't want to be too restricted, or the buyer to have too much oversight about what they're doing day to day, but the buyer will need some degree of comfort that you're going to keep running the business. Termination rights. So this is the scenarios in which the deal doesn't go ahead. That's obviously something that will be, a point for negotiation. Restrictive covenants. So this is more about the period after you finished the sale and saying, you've sold me this company, but potentially a buyer. Depends on the industry, because there are some industries where competition is just a really sensitive point for the deal, and you don't want to buy a company to pay all of this money for this value, and then for the seller company to poach back all of the management team, or to immediately set up a new division that does exactly the same thing as the business that they have sold. And sort of, the company, the group as a whole may already have a lot of goodwill, and they can just immediately compete and undermine the value of the business that they've sold. So that, the sort of not doing of certain things in order to preserve the value of the business of that target that you've sold. That's what we mean by restrictive covenants. It's not doing something, not soliciting staff, not competing as a business. Those will be, heavily negotiated points. And then deliverables are anything else that you need delivered to you on closing. So that's everything down to like small bits of paper that you're like, I need you to deliver resignation letters from certain, directors. I need you to deliver all of the share registers of the company so that, we have them in our possession. Anything like that, you just have to put thought into what are all of the things that we physically need delivered from the other party in order for us to close. So that's whistle stop tour of the SPA. I will. I was going to say, I think we should sort of wrap this up into the disclosure letter, but I'll let Alex.
I can speak about the warranty deeds and warranty with the disclosure. Essentially, warranties are statement of facts that the seller gives. It helps to encourage disclosure, because whatever is disclosed, the seller is essentially not liable for. So it's a way of apportioning risk between the buyer and the seller. And it's given at signing, because that's when the buyer is locked in, but also repeated at completion. This is when there is a gap. But this isn't always the case. And there are different types of warranties. So there's fundamental, business, and operational. So fundamental is really the seller's capacity. So if it is a share sale, it's looking at whether they do have ownership of shares, and if they're able to enter into the transaction. And in one particular deal I was involved with, we realized through due diligence that the seller actually didn't have all the shares. There was like a mistransfer in like years ago. So again, it shows the importance of due diligence and disclosing properly and asking follow-ups to the target if necessary. Business and operational are the day-to-day warranties about the business, employment matters, compliance with laws, whether there's litigation ongoing, and so forth. So the target might say, the management might, one of the warranties might be there's no litigation or there's no dispute with employees, but they may try to narrow this by materiality and knowledge qualifier. So for example, so far as the seller's aware is a knowledge qualifier, and they might also add a the no litigation might be no material litigation, if that makes sense. And it's again subject to the disclosure letter, because this is a letter that the seller provides to the buyer, which sets out they disclose everything against what they've the warranties that they provided in the agreement. So if it was like the no litigation example, they will disclose any ongoing litigation or anything they know that might go against that the warranty that they've provided. And there are just different types of disclosures. So there is a general disclosure and specific. So general are things you can find through your the data room or in the public information, like Companies House, for example. And specific disclosures are really the one that relates back to the agreements, the warranties, and this could be very long. And as a buyer, you want to make sure the specific disclosures are as narrow as possible, and as the seller, you want to make sure your disclosures are as wide. That was a very, very fast explanation of the warranties and disclosure letter, because I know we have some time left for Q&A. But before we get into that, and provided Lucy, doesn't have any further comments, I can just very quickly, I'm going to skip this slide, but explain the trainee role. So I've addressed a few of the things we do as a trainee. So I won't get into like the due diligence at managing data room aspect, but other things you can get involved is preparing ancillary documents. And what I find interesting in PE, maybe compared to some other departments, is that there are so many different documents flying around, and as a trainee especially, I saw at ropes, like if you put your hand up and say, can I get involved with drafting this, like most of the times you can get involved. And if you're not drafting it, you can definitely be reviewing documents. And this is also always run through another associate, so you could sort of compare what they may have added or what they may have changed, and this is a good learning way of learning for trainees. Other roles you might be involved with is, again, coordinating with different teams, and also coordinating and compiling signatures when they come in. So now a lot of documents are signed online, but as a trainee, you're the one responsible of putting together the documents to be an executed version, and then putting them together into what is called a Bible, and making sure it goes to the right person, and making sure that some documents are confidential, so making sure that you are making sure the right person gets it. You are also involved with filings, so this is companies' house filings often. So if there's a change in shareholder or an allotment of shares and so forth, you're updating the company's house, but also the company's books. So these are like the registers, and there's quite a few. So and there's also deadlines to do this. So again, this is something you have to be mindful as a trainee. And so I would say that like learning process management is one thing that being sat in PE or working in PE really helps you learn as a trainee. There's, I would say, less research element, but that's not to say there's none, but there's more process work, and you could really become an expert, in 6 months, and continue to, develop that once if you decide to join or go to another transactional seat. So that was a very short explanation of the trainee roles and some of the documents. But accepting questions, I guess.
Yeah, thank you both sorry. Thank you both so much. This was great, and it feels like we never have enough time for these sessions, do we? Kind of following up on the trainee role, someone has asked, how to show interest in private equity in applications or interviews, and like any advice for them to develop their knowledge in the field. I know, Alex, I believe, correct me if I'm wrong, you were a trainee quite recently up until you became an associate, so maybe you'll be able to help with that one, but also Lucy, feel free to jump in as well.
Is it how to show interest again? Sorry.
Yeah, in applications or interviews. Yeah.
I think it's always, I found that my interviews and the ones that where I like related it back to myself is ones where I was able to show the most interest. So that could be what you've done in school or what you've read in the news, but you should always sort of tie that in the interest back into yourself and also the firm, because it wouldn't be that helpful if you end up talking about something that the firm actually doesn't do. So loads of PE firms, as in legal firms here, a lot of them have specialist niche as well. So, understanding that is important as well.
Perfect. And kind of going off of that, a few people have asked, well, both of you, what drew you to private equity as a practice area and why you kind of chose to specialize in that area as well?
I'll let Lucy take this one.
Yeah, I mean, I think you'll hear this answer more and more as you ask people that question, and that is that quite often you don't go into your training contract with a specific thing in mind and then end up in that practice area. I think there's, the best thing that you can possibly do when you are still a student is to just have a really open mind. A lot of the skills that are described in the trainee role that we look for our trainees to do in PE, these are completely transferable skills to things that you would take forward into other practice areas. And so there may be this practice area that you've just never even thought of that will actually, you might use these same skills, but that one will just strike up something, and you'll be working with really good people, and it will just be really interesting, and it could be completely different from what you thought going in. So I would say going in, when I was still at law school, I would almost certainly have told you that I was going to be a litigator. And private equity is almost as far from a litigator as you can be. And I think what drew me to it when I was a trainee was the degree of collaboration that is involved. So a lot of the organizational skills are similar to what you would do when you're a litigator, but litigators are very, this is my client's position, and it's very adversarial, and what we do is much more collaborative with there's negotiation, but you ultimately all want a deal to go forward, and I really liked that element of it when I was a trainee, and it's the order of the seats you do. I just think you should be open-minded to everything, and you should be very thoughtful when you're a trainee about what seat comes next, what seat builds your skills, or what your interest is within the firm that you're in, because that path will then unfold to the place that you land, I think, when you qualify.
Perfect. Thanks so much. I'm aware we're overrunning. I think we could go and do one more question, which is from Jan, and they asked what's some of the most common legal pitfalls that arise during the life cycle of a private equity deal, and how can they be effectively navigated?
Interesting question. I mean, I don't know. I don't know if I would necessarily use the word pitfalls, but there are definitely some challenges that can come up unexpectedly during a deal. Some could relate to how you deal with an unforeseen, the diligence, or perhaps something has happened during the time that you've been looking at the deal, that's something's come out, you've completed, the company has completed its financials, and something's not performed as well as you thought, and you basically all of these things is coming back to what Alex was saying about due diligence, and the reasons that we do due diligence, or the disclosure letter, and getting the seller to promise, make all of these statements of fact about the company, and then to give you disclosures, is that all of that is leading to telling you about what you might think of as pitfalls, things that you maybe didn't know about, or that have come out, some kind of litigation, some kind of maybe the company's not performing quite as well as you thought. And the main reason, there's two kind of reasons that you do all of those steps, that kind of constant diligence and disclosure process, is so that you can either, as the buyer, chip the price, or that you can manage the allocation of that risk. If you're going forward, ultimately, I suppose there's a third option of that you could walk away and the deal could fall apart. Sometimes that does happen, but really the main way that you navigate is that you get into the drafting and you allocate the risk of what has come out between the parties. That's how you navigate it, and that may involve the price of the company, as the target group, is worth a little bit less, or it may involve some other way of allocating risk, like promising that if that materializes into this bigger cost that it potentially could, that you'll indemnify them. And so that's probably what I would say there, is that you do it in the drafting of the SPA.
Amazing. Thank you so much, Lucy. Oh, Alex, sorry.
I don't know, just other things that maybe might be like unexpected antitrust clearance that we all thought we didn't need, but you ended up needing it. Or, you might have closed a deal without getting clearance and then, signed a deal, and then, the antitrust competition authorities in one country might have decided, oh, actually, we don't want this to close. We weren't notified. And so that might actually be a reason to have to unwind a deal. Or maybe sometimes management might not be too forthcoming about some of the issues and might have downplay it when it's actually material and affects, as Lucy said, the price element. But yeah, that's about it. And yeah, that's absolutely true with sort of antitrust, and the main way that we would navigate that is by working really, really closely with our antitrust team. Like, that's a specialist team that we work with really closely in corporate, and keep them updated. And we do our analysis. The other side, it doesn't matter which side you're on, like buyer, seller, you would both run antitrust analysis in an attempt to make sure that you do know when filings are going to be needed, or that you speak to regulatory authorities. But it's just that's why we put that on the sort of the outset slide as something to be mindful of, is because you really don't want that one to sting you. But the way that you would work through it is with your antitrust team, with the buyer. Ultimately, hopefully you can still get to a place of a deal, but it does sometimes involve extra negotiation and compromises.
Amazing. Thank you so much. I'm just going to quickly run a final poll. Thank you to everyone that was stuck with us. 1 second. So this poll is to get an idea of what everyone's key takeaway is. So if you could please answer the poll on the screen. And while you do that, just to let you know that before you go, just another reminder to attendees that we will be sending out a link containing the recorded session. So please keep an eye out for that. A survey will also be popping up once this masterclass has ended. So please fill that in to let us know how you enjoyed today and what other topics you would like to see us cover in the future. And speaking of surveys, there's still time for you to vote for your Student Law Society in the 2025 Student Law Society Awards, sponsored by Barbary. The awards celebrate the hard work of student law societies across the UK. So make sure to complete the survey, which will be linked in the follow-up email for this session as well. Just having a look at the poll now. Sharing the results as well. I see majority of you have said that you've gained valuable insights into the life cycle of a private equity deal, which is great. And also a lot of you have learned about what lawyers do in this practice area, which is great. Just a final reminder for everyone attending to refer to the events page on Law Careers Net for the masterclasses I've already mentioned. And thank you very much once again to our panelists, Alex and Lucy, for this amazing session, and to everyone attending as well. And we look forward to seeing you again next time. Thank you.